Okay, good afternoon, everyone. My name is Andrea Lee. I'm a partner at Glaholt LLP.
I'm Heather Michael, an associate at Glaholt LLP.
Welcome to Glaholt LLP's webcast on prompt payment and adjudication, regimes that will be coming into effect in Ontario in 6 short months. So today, Heather and I will be discussing the nuts and bolts of prompt payment, what to do when you get a proper invoice, how do you create the proper invoice, and we'll be reviewing a few scenarios that might come up on a project. Then you'll have John Margie and Max Guinness of our firm speaking on adjudication, how to navigate the process, how to be best prepared for the strict timeframes under adjudication. And then you'll hear from Brendan Bowles and Lena Wang on adjudication and beyond. So what to do when you get a result that you're not all that pleased with. What about adjudication in alternative financing and procurement situations, and the other rights and remedies that exist alongside adjudication. So with that comment, I'll turn it over to Heather to get us started on prompt payment.
Thanks, Andrea. So turning to prompt payment, we'll start by looking at the kinds of projects that fall under the prompt payment rules. And essentially, as long as you've determined that the contract was entered into or the project was procured after October 1st, 2019, the rules will apply with one major exception. So the rules will not apply to any portion of an alternative financing and procurement or AFP project agreement that provides for the operation or maintenance of the improvement by the special purpose entity. So once you've determined that the prompt payment rules do apply to the project, the rules about giving a proper invoice will be triggered. So what constitutes a proper invoice? Section 6.1 defines it as a written bill or other request for payment for services or materials in respect of an improvement under a contract, as long as it contains the information required by the Act and, subject to Section 6.3 sub 2, meets any other requirements that the contract specifies. And we'll look at the information required by the Act next, but note that Section 6.3 sub 2 says that the giving of a proper invoice cannot be conditional on a payment certifier providing certification or on the owner's approval, subject to two exceptions that we'll discuss later on slide 16. So as we just saw, Section 6.1 says that a proper invoice has to contain information required by the Act. And that information includes the following list of items, such as the contractor's name and address, the date of the proper invoice, and the period during which the contractor or the services and materials were supplied, etc. And you'll note that item 7 includes any other information that may be prescribed. So far, there's nothing else set out in the regulations for what should be included in a proper invoice, but it's something that you'll want to look out for in the future. Now, you'll recall that Section 6.1 also says that a proper invoice must meet any other requirement that the contract specifies. So in addition to the information prescribed by the Act, you'll also have to carefully review the contract for any additional information that's required. So when you are entering into contracts, be wary, if you're the contractor, as to what an owner will require to be submitted as part of a proper invoice, in addition to those statutory requirements that were listed on the previous slide. Now, also keep in mind that contractors are not just builders, but also include designers or anyone else who engages in a contract directly with the owner. You should also note that the requirements for a proper invoice do not change the holdback obligations, and these should still be included on the invoice. So here we've prepared a basic checklist of information required for a proper invoice that can be used either when you're preparing the invoices or when you're checking to see whether a submitted invoice conforms with the requirements. If you're a contractor, we actually suggest completing the checklist by adding any additional contractual requirements at the start of the project and getting sign-off from the owner so that you have a clear list of what you're required to include in that invoice. We've also prepared a basic example of a proper invoice, and the information in black is what's required under the Act, and the information we've included in green are items that may be required under the contract. With respect to interest, just a note here that Section 6.9 provides that if a contractor or subcontract does not specify an interest rate as part of the payment terms, then the prejudgment interest rate, as set out in the Courts of Justice Act, will apply. Now, if the interest rate is specified, whatever is the higher between the contract rate or the Courts of Justice Act will apply. So now that you've prepared a proper invoice, when and how do you give it? With respect to when, Section 6.3 sub 1 of the Construction Act says that a proper invoice shall be given to an owner on a monthly basis unless the contract provides otherwise. So you'll want to be sure that you're checking the contract for any terms that require proper invoices to be given upon completion of certain milestones or in accordance with a specific schedule. With respect to the giving of a proper invoice, Section 87 sub 1 defines given as being served in any manner permitted by the rules or sent by registered mail to the recipient's last known address. Now keep in mind that a standard form contract will typically set out how invoices are to be given and to whom. And you'll also want to note that the trigger for payment by an owner or the owner's delivery of a notice of non-payment is when the proper invoice is received, not when that proper invoice is actually given.
So now we'll take you through a couple of scenarios which might occur on a project. For example, you might have a contract requirement that provides for a draft invoice to be given in advance of a proper notice being, a proper invoice being delivered. And in our view, such a clause, if you're dealing with a non-AFP project, such a clause would run contrary to the intent of the Act. If you read the two sections that we've set out in the middle of the screen, Section 5.1 and Section 6.3 sub 2, you'll note that every contract or subcontract is deemed to be in conformance with the Act. And also, as Heather touched on briefly earlier, a provision in a contract which makes the giving of a proper invoice conditional on an owner's approval or a certificate of payment is prohibited. So we take the reading of these two sections together to indicate that if there is such a clause which requires a draft invoice to be provided in advance on a non-AFP project, then it is likely that even if you miss the time frame, you wouldn't be prevented from giving a proper invoice in accordance with the Act, and the prompt payment rules would still apply to you. Now note, we did put the AFP exception down at the bottom of the screen at Section 1.1 sub 2.1.2, which just provides that Section 6.3 sub 2 prohibition of a clause which requires a certificate of payment or owner's approval to be given along with a proper invoice. That clause basically says that section of the Act does not apply to AFP projects.
So what happens if you submit an invoice to the owner and then you receive a late invoice from a supplier? So this late invoice can be added by revising the proper invoice in accordance with Section 6.3 sub 5. Now, if the owner doesn't agree to the revision, in our view, you'd have to submit the late subcontractor invoice with the next proper invoice. And note that the timeframes for payment by the owner or the issuance of a certificate of non-payment are still running from the date that the proper invoice was initially received.
In this scenario, we're looking at a contract that perhaps specifies that proper invoices are to be given on the 1st of each month, and a contractor submits an invoice on the 29th of the preceding month. And in our view, the question might arise, does the timeline for prompt payment and the notices of non-payment get triggered on the earlier date or on the contractual date? And in our view, it would be the latter. The contract date would apply because, again, if you look at Section 6.3 sub 1, it sets out there that proper invoices shall be given to the owner on a monthly basis or as specified by contract. So arguably, if the contract says you've got to submit proper invoices on the 1st of each month and you submit it outside of that time frame, it could be arguably not a proper invoice, and the timelines for prompt payment are therefore not triggered.
So in the next example, the contract says that invoices are supposed to be submitted on the 1st of each month, but the contractor submits the invoice on the 3rd of the month. So because the invoice was given outside of the time frame stipulated by the contract, it would be unlikely in our view that this would be considered a proper invoice, and you'd likely have to submit it the following month. However, if the contract was silent with respect to the timing for delivery of the proper invoice, for example, it might just say that proper invoices should be delivered monthly, then arguably, as long as it's the only invoice delivered within any given month, you'd be okay.
And now we come to certificates of payments. Most standard form contracts likely still provide that certificates of payment will be required on a project. But again, bear in mind section 6.3 sub 2, which in a non-AFP situation states that the giving of a proper invoice is not conditional on a prior certification. So how would a certificate of payment work within this context? So, you know, we can imagine that a contract will still provide, that a consultant will review invoices, will provide a certificate of payment to owners and the parties to look at, and the owners can rely on that information to either make the payment or send out a notice of non-payment. But, you know, in our view, an owner can't simply rely on the absence of a certificate of payment to say, I'm not paying and my prompt payment obligations haven't been triggered. This would, you know, obviously put a lot of pressure on consultants who are under tight timeframes to review invoices and get certificates of payments to owners. And for this reason, you might see consultants building up their teams who are responsible for contract administration over the next few months. And again, we do note that there is an exception for AFP projects and also the testing and commissioning portion of contracts where section 6.3 sub 2 does not apply.
So our last scenario involves the inclusion of a pay when paid clause in a subcontract, meaning that the subcontractor will be paid only when the contractor receives payment from the owner. And because you can't contract out of the Construction Act, in our view, a pay when paid clause would be void.
So now that we've reviewed a couple of these scenarios, how could we best set up for invoicing on projects? And so we've created another checklist here, which we think might be helpful. So obviously the first two relate to actually setting up that proper invoice, creating the checklist and updating your invoice templates to make sure you're getting all of the information that's required in the checklist onto the invoices for that particular project. The third and fourth bullets deal with creating deadlines. So create a deadline for when the contract requires invoices to be submitted, or if the contract is silent, follow the monthly timeframe set out in the Act. And also set up advance reminders to the project team to make sure you're getting together all of the documents required to be submitted with the proper invoice. The other deadlines that you want to be wary of are when an owner will be sending out payment or notice of non-payment, because that'll obviously trigger for a contractor a number of other steps as well. And just the last point here with respect to giving your subcontractors confirmation of the date on which you submitted the proper invoice, that's to address section 6.5 sub 10, where a subcontractor who is required to pay can ask a contractor for that information. Obviously, it affects their obligations under the prompt payment regime. So, if you want to make sure that you're being responsive to your subcontractors, you could in fact just give them that information as you submit the proper invoice. When it comes to reviewing a proper invoice, we thought we would go over some of the key points that we think might be useful in this process. So firstly, to check for a couple of preliminary things to make sure the invoice is in fact proper. One, has it been received on the correct date? And two, has the proper invoice met all of the elements set out in the checklist. Again, this is why it would be helpful to create a checklist in conjunction with other parties to make sure everyone's on the same page at the outset as to what will be required to be submitted with the invoices. And then if you're reviewing the invoices on behalf of an owner, it's helpful to set out for the owner when their notices of non-payment and payment will have to go out, being triggered by the date of the receipt of the proper invoice. And if you have to provide a certificate of payment under the contract, then set that time frame out for yourself as well as a calendar reminder. And of course, when it comes to actually reviewing the substance of the invoice, there are a number of things an invoice reviewer could be looking at in the ordinary course: deficiencies, unapproved changes or approved changes, and holdback, as Heather mentioned earlier. Still have to make sure that amount is correct. And finally, set-offs as set out in Section 6.7 of the Act. And now we're going to run through a few flow charts which just show you the scenarios of how payment can either be made in full or not at all, or part payment be made at one level and full payment be made on other levels. And so we'll run through these one at a time. On this slide, we've got here for you on the left what happens if full payment is made, and that flows all the way down the chain in time. And on the right side of the screen, we've got what happens when no payment is made, $0, and what happens down the chain. And so you'll see under the full payment scenario, once the contractor is paid in full, and this has to be done within 28 days of receiving the proper invoice, then the contractor has 7 days to pay down. That subcontractor has another 7 days after receiving the money to pay that down, and so on. And we've just put the sections of the Act which apply next to each of these steps. And on the other side, if you've got the owner saying, I'm not paying this invoice at all, there will be a notice of non-payment that has to go out within 14 days of receiving a proper invoice. And again, we've got the sections that apply as well as the forms that are going to be used. So these forms are available online, and they apply to very specific scenarios. So where the owner gives a notice of non-payment, it's Form 1.1. Then within 7 days of receiving that notice, the contractor gives notice of non-payment to its subcontractor using Form 1.2. That form contains an undertaking that the contractor will also refer the matter to adjudication within 21 days of giving the notice to the subcontractor. And then again, the subcontractor's obligation to send a notice of non-payment to its own subcontractor follows from that, and they would use 1.4, Form 1.4, which also includes an obligation or an undertaking on that subcontractor to refer the matter to adjudication. And these are the sections here. I'm not going to go through them in any great depth, but these are the sections that apply to the full payment scenario. And these are the sections which apply to the non-payment scenario that we've just reviewed. And so what happens if there's part payment? The owner decides for some reason that perhaps a particular subcontractor wasn't performing, or that the amount, the percentage of the work complete as set out in the invoice is actually incorrect. And so they'd like to make payment in part, but not the full amount that's been invoiced. And so on the left side of the screen, we've got what happens to the amounts that the owner agrees to pay. And on the right side of the screen, we have the unpaid amount and what happens there. So following the paid amount, again, it's the paid amount is to be paid to the contractor within 28 days of the owner having received the proper invoice. And then that contractor flows down the payment within 7 days of receipt, and so on and so forth, as set out on the slide. However, if you look to the right side for the unpaid amount, there the owner will have to give notice of non-payment, and that notice also flows down the chain from the contractor to the subcontractor, and then, of course, the adjudication undertakings are also given. Just as a note here that payments to subcontractors are going to be made ratably, or if the owner at the very outset has specified something different, then it will follow the owner's specification there. In the next scenario, we've got part payment being made by the owner, but the contractor making full payment. So this could happen in a scenario where the contractor forgets or fails to give a notice of non-payment to its subcontractor, or perhaps a contractor might acknowledge that there was some failure on its part, which justifies some refusal to pay a portion of the invoice. In any event, if you follow the left side of the screen, again, this is the paid amount flowing through to from the owner down to the contractor to the subcontractor. Note the first time frame is 28 days within receipt of the proper invoice, and then after that, it's 7 days following receipt of payment. On the right side of the screen, we've got the unpaid portions. So here, what's different from the previous slide is that after the owner gives a notice of non-payment within 14 days of receiving the invoice, there's no notice from the contractor, right? So without that notice, the contractor then has to pay the balance of the unpaid funds to its subcontractor within 35 days of giving the proper invoice. So it's not being triggered by the receiving of the proper invoice, it's being triggered by the giving of the proper invoice. And so there, the subcontractor is paid the balance by the contractor within 35 days of giving the proper invoice. And you'll note that roughly the time frames for the subcontractor to receive what should be in this scenario the full amount is basically an outside time frame of 35 days, both on the paid amount chain and the unpaid amount chain. And here we've put adjudication in a dotted box because we've just want to draw attention that in the notice of non-payment scenario, the contractor's undertaking to refer the matter to adjudication within 21 days is triggered by their notice of non-payment to the subcontractor. So if there was no notice to the subcontractor in this scenario, they don't have that 21-day window that they have to refer the matter to adjudication. But as John and Max and Brennan and Lena will get into in a bit, adjudication can be triggered by a number of things, not just notice of non-payment. And finally, we come to our last scenario where there's been full payment made by the owner, but for some reason the contractor wants to hold back some of that amount. Perhaps a deficiency became apparent after the invoice went in, and the contractor wants to hold some portion of the money back until it gets addressed. So here we have full payment being made to the contractor within 28 days of the proper invoice being received, but now note that the contractor is going to give notice of non-payment to the subcontractor, and that notice has to come within 35 days of giving the proper invoice. There's a distinction here because this is a scenario where the contractor has received the full amount from the owner as opposed to just receiving part payment from the owner. So where you've received full payment within 35 days of giving the proper invoice, you've got to give the notice of non-payment to the subcontractor, and this is using Form 1.3. At the same time, for the amount that the contractor is paying, it's got 7 days from the receipt of the payment from the owner to flow whatever it is agreeing to pay down to the subcontractors. And then again, if you follow the notice of non-payment side, when the subcontractor is then in turn giving its notice to its subcontractor, it also has to use Form 1.4, which contains within it that undertaking to refer the matter to adjudication within 21 days. So now that that is all clear as mud, I will turn it over to John Margie and Max Guinness to lead you through adjudication.
Hello everyone, my name is Max Guinness. I'm an associate at Glaholt LLP, and I'm here with John Margie, who is a partner at the firm. We're going to talk about adjudication, the timelines for an adjudication, and some practical aspects for dealing with an adjudication. As a reminder for everyone, adjudication is meant to be a quick and dirty determination of a dispute. It is meant to be a fast and interim binding process where if a party is unsatisfied with the result, they may litigate or arbitrate.
I like to think of the three bullets on the slide as three foundational principles of adjudication. But make no mistake about it, adjudication already has its critics. Some people complain that the timeline's too short. Others say that the process is completely flawed and won't result in a good decision, or perhaps even a flawed decision. But adjudication was never intended to be a perfect system. It's really a mechanism to get disputes resolved in a quick manner. And that, of course, then takes us to our timeline.
So I'd like to go over the timeline on an adjudication. Now, under Section 13.7 of the Construction Lien Act, or the New Construction Act, specifies the requirements for a notice of adjudication. A notice of adjudication must contain the names and addresses of the parties, the nature and a brief description of when it arose, and including details respecting how and when it arose, the nature of the redress sought, and the name of the proposed adjudicator to conduct the adjudication. Now, the parties can either agree to an adjudicator or request that the authorizing nominating authority appoint an adjudicator. If the adjudicator does not consent within 4 days after the notice of adjudication, the party who gave the notice shall request that the authority appoint an adjudicator. 5 days after the adjudicator agrees or is appointed, the party who gave the notice of adjudication must provide a copy of the notice and certain documents, and we'll go over those documents a few slides from now. Now, after transmission of the documents, as per the proposed changes to the regulations, a response must be forthcoming within 7 days. The adjudicator shall make a determination no later than 30 days after receiving the documents from the referring party, but that can be extended by 14 days on the adjudicator's request or with the written consent of the parties. Parties have 30 days to make an application for judicial review of the adjudicator's determination, and if the adjudicator determines that payment must be made, the payment must be made 10 days after determination of the adjudicator has been communicated. So John, looking at this diagram, what jumps out at you the most?
Well, there are a couple of things that jump out, I think, and it is, of course, the timeline. If you look at the overall timeline, it's about a 45-day period from the notice of adjudication down to the delivery of the determination by an adjudicator. And unless parties on a construction project are negotiating their dispute and come to a resolution within a day or two, to have a third party receive submissions and make a determination on a dispute between them within a 45-day period, I think is quite remarkable. Another aspect of the timeline that I find that jumps out at me is the proposed time period for a response. Currently, the Attorney General's office has put out a proposed regulation that has the responding party delivering its response within 7 days of receiving the adjudication materials. I think that maybe in the end, perhaps we'll see that period will be maybe a 10-day period, but that remains to be seen. But that, make no mistake about it, that is a very quick timeline to deliver responding material. And one other aspect of this timeline that I think perhaps results in a gap related to the timeline is the Act currently provides that the fees of the adjudicator are to be agreed upon prior to the commencement of the adjudication. Now, I'd always thought that the adjudication commenced with the delivery of the notice of adjudication. So it's difficult to see how you're supposed to identify your adjudicator, resolve the fees, and then deliver your notice of adjudication. Perhaps that'll require some clarification from the Attorney General's office, and I think maybe what you'll find is that the timeline for the 5 days for the adjudicator to accept their nomination, it'll be during that period of time that the parties and the adjudicator agree on fees. Of course, now that we've kind of set out the timeline for an adjudication, you have to be cognizant of the fact that You can only refer what's identified in the Act as a dispute to adjudication. However, under the scheme, there's no definition of what constitutes a dispute. Perhaps in time, the courts will identify that as being nothing more than the plain language as one would understand when you have a dispute. In Canadian arbitration law, our courts have defined that a dispute arises when it's crystallized, but of course, that begs the question, when is a dispute crystallized? In the UK, under their adjudication law, they've already addressed this issue, and they've said that a dispute arises when there's an express rejection, when a party wavers as to what its position is on an issue, or thirdly, a party just remains silent and says nothing. But until we get some clarification as to when a dispute or what a dispute is or how the courts are going to define it, of course, there's a possibility that people will game the system. So you can imagine that someone will try to insert contract terms that will provide that where an issue arises, you have to negotiate it, for example, at the site level, then perhaps at the executive level, and if still no resolution, then refer it to the consultant. And once the consultant has made a determination, it's at that point that if you don't like or are unsatisfied with the result, that's when you have a dispute. Now, imagine if that process took you 6 months to go through in accordance with the contract terms. Well, that to me would be contrary to the Act and the spirit of adjudication, and I think that a court will likely find such provisions to be inconsistent with the Act. But again, that remains to be seen.
Section 13.5 of the Act specifies the kinds of disputes that can be referred to adjudication. Now, if you look closely at the list that is on the screen before you, you'll see that they all essentially deal with money. Let's take the first item, for example. That's the value of services and materials. The next one refers to payment, and so on. Now, you'll notice that conspicuously absent from the list of disputes that can be referred to in adjudication is anything related to time. The first type of dispute you can have that can arguably be used to ask for compensation for delay. And of course, in order to determine if you are entitled to compensation for delay, the adjudicator would have to make a determination about whether or not you are entitled to additional time. The fourth type of dispute is amounts retained by way of set-off. Typically, where a contract permits the owner to charge liquidated damages for failure to complete on time, it allows the owner to set off the liquidated damages against amounts owing to the contractor. Again, arguably, you can determine whether the owner is entitled to retain amounts for liquidated damages and therefore determine the time issue under this fourth type of dispute. It is unclear whether or not this is an intentional drafting point to exclude time, perhaps in order to avoid having adjudicators deciding complex extension of time claims.
Max, that's a very good point that you raise as to whether or not extensions of time are included in the types of disputes you can adjudicate. But it also highlights something very important when drafting your notice of adjudication. I think you have to be very careful in how you craft what you're asking for. So if you're asking for the value of services or materials provided, that's easy enough. That's one of the types of disputes that you can adjudicate. However, if your notice of adjudication asked for an extension of time, I think that what you'll find is that the other side will object to that because presumptively, based on the types of disputes you can adjudicate, an adjudicator has no jurisdiction to determine an extension of time. And perhaps therein lies part of the problem that we might see with adjudications going forward.
There are two mandatory documents that need to be provided to the adjudicator. The first is the notice of adjudication, and the second is the contract or subcontract. Any other documents are optional in the sense that you need to measure what supporting documents you'll need to win your adjudication. The Act is broadly drafted in the sense that you are entitled to send to the adjudicator any documents you intend to rely on for the adjudication.
And that is actually the point. The Act is very broadly drafted in terms of what you can rely on in terms of your adjudication submission. Presumably, one of the things, of course, that you'll want to have is a written submission that will outline for the adjudicator what the dispute is about. The written submission can be detailed, it can have merely a broad overview, but it might also require that you produce other documents. So, for example, if you were going to have witness statements, if the dispute related to an oral instruction with respect to a change, I think in that situation, you'd want to have a witness statement of the individual who received the oral instruction for the change. In addition, you might have to consider things like, do I deliver expert reports with respect to, in my example, what the value of that change is. I come at it from the perspective of you want to be able to give to the adjudicator sufficient documentation supported by the written submission being your story as to why you're entitled to win. You want to give to the adjudicator the documents that the adjudicator needs to find in your favor. So that puts us onto our next slide about the documents that you need to rely on. And in many cases, that'll depend on the type of dispute that you're adjudicating.
Yeah, so let's take, for example, a dispute over the payment of holdback, which is fairly common in the construction industry. Obviously, you'll need documents to confirm that the lien period has expired, so you'll want to publish certificate of substantial performance. You'll want to show that there are no liens registered on title, so you'll want an updated abstract of title. And you'll also need to quantify the holdback to be released, so you'll need documents, maybe the last progress certificate setting out what the holdback is. And then, of course, as John mentioned, you'll have your written submissions detailing all of this for the adjudicator, and perhaps correspondence between the parties detailing the dispute over the payment of holdback and one party's failure to release holdback.
And another type of dispute will be the value of services and materials provided. And so aside from the written submissions, of course, you can see the list of documents that you may rely on. As I said before, the written submissions could be broad, but refer to, for example, witness statements that you'll submit or other documents. And then the witness statements themselves could be very detailed as to why you're entitled to the value of services that you're claiming. One thing that you also need to remember about this process is that the adjudicator is given the power to take the initiative to ascertain the law and the facts. So after you've made your submissions or delivered your submissions to the adjudicator might have some questions, or significantly, the adjudicator may ask for other types of documents that you haven't provided, or specific documents, certain letters, for example, or emails that are referred to by the parties but not actually provided to the adjudicator. And you have to be ready to address those requests by the adjudicator, because you got to remember, you're running with a very short time frame.
Now, on this slide, we've listed a wide variety of documents that you might rely on for a dispute under the value of services and materials provided category of adjudication. And we just want to highlight a few points about how to best manage these documents. So, for example, meeting minutes. It's very important during the project that if you have issues with the contents of meeting minutes, that you raise them at the earliest opportunity. It can be easy as emails and documents pile up in your inbox to not review meeting minutes, but it's a lot easier to raise your concerns at the outset than it will be months or years down the line when you have to deal with them at an adjudication and you're suddenly saying, hold on, this isn't how I remember things. Daily reports, it's best to have them as detailed and accurately prepared as possible. Again, by doing this at the outset, you will save yourself a lot of time and make your case that much stronger. Photographs. As lawyers, we often get photographs when it comes to preparing an affidavit of documents or productions. They come in the thousands, they aren't described, they're often vague or blurry, and we don't really know how to make heads or tails of them. So an accurate photo log or clearly dating and labeling your photographs will make it a lot easier to pick up the pieces later on and to use them and to have them be a helpful tool in your adjudication. And finally, as John mentioned, witness statements. Witness statements should be considered a bit of a last resort. If you need to tell your story through a witness statement exclusively without supporting documents, you may have some problems. However, if the witness statement is supported by contemporaneous documents, it is that much more likely to be accepted and given good weight.
Max, that's an excellent point related to contemporaneous documents. It's important to remember that in many cases, an adjudication may be conducted only through the use of documents. And by that I mean through the project records. And so you want to ensure that your project records are current, they're up to date, and essentially that they tell the story. You want your project records to be, I think they should be sufficiently detailed so that you can rebuild your project through the paper alone without having to rely on witnesses. So, for example, if you're a construction manager and your records have to be very meticulously kept, they have to be organized, they have to be up to date, so that you can assist an owner to respond to an adjudication in the very short time frame that the owner will be required to respond.
Yeah, John, I agree. You really want the documents to be able to tell the story of your dispute. It's a bit trite, but show, don't tell is a good rule of thumb when it comes to preparing your materials. Courts have typically favored contemporaneous documents, and adjudicators likely will also. Now, another important tip is that project teams have high turnover. People will go to different projects within a company. They may go to different companies, different jurisdictions, different provinces, even countries. And they might take their notes or their laptops with them. And that presents real challenges when you have this tight timeline for an adjudication and you need to find these documents within days. So it's really important to get control of the laptops, get control of the notebooks as people are moving around projects or companies, and that way you can avoid those potential issues.
So the key to dealing, I think, with an adjudication will be to remain organized. And as a best practice, I'm sure a lot of companies already have it, but they have a document management system. You got to ensure that your document management system is set up on a project-by-project basis. Something that companies might want to have is a standard filing system so that whenever you have a new project, a certain number of files identified as change orders, whatever it might be, but it's a standard filing system that, that is used company-wide. And then ensure that your people are trained and vigilant, and ensure that they file the right documents into the right file folders so that documents can be located really quickly. Our second bullet on the slide is you might have to consider hiring somebody who'll look after organizing the paper. And I know that a lot of people will think that, well, that's just another, an additional cost. It's going to make the project more costly. We probably won't get the work. But I think that if you find that you're struggling to find paper or your paper just isn't good enough, then you might want to really rethink this so that you ensure that you're able to find paper so that your paper does accurately reflect the construction. And in that respect, I come at it from a risk management perspective. And because adjudication is here and you have to deal with it, doing these things is just now part of your risk management, or it should be.
Yeah, John, those are good points. So maybe let's look at a few practical ways that you can develop a protocol that will help going forward, not only in an adjudication, but in litigation or in arbitration. So, for example, emails. We often see that we'll get email threads going over months, even years, where a conversation will continue even though the title of the email does not reflect what is being talked about because this conversation has just devolved into something completely different. And that makes finding specific information fairly difficult. So one protocol could be in terms of titling your emails, using separate threads for separate topics. That will make it a lot easier for your project personnel to sift through them and find the emails that you want to deal with a specific issue. Another one can be confirming instructions by email. Now, a lot of disputes over extras take place because the two parties have a disagreement over what the actual instructions were or whether or not a party was authorized to proceed with work. This could easily be resolved if, upon receiving instructions, the party receiving the instructions confirm them to the other party via email. That way you can hopefully clear up some misunderstandings early on before the dispute arises, but in any event, you will have a contemporaneous written record that can be used in your adjudication.
So here in Ontario, with adjudication coming into effect in October, we are the early adopters of construction adjudication. And we appreciate that, some of the tips we've tried to give today won't fit all, because not one size fits all. Companies vary in size, they vary in capability, sophistication, and the requirements, but you can't ignore adjudication. You have to start thinking about a protocol to institute so that you can bring an adjudication, and more importantly, you have to think of a protocol that you can have in play when you're responding to an adjudication. Your protocol, for example, might indicate that there is a single person in your organization, or perhaps two people, that are identified to deal with adjudication and marshal documents and people so that you can respond in the tight timeline.
The people who really know your company best are the project personnel who are on the ground. They'll be able to tell you what is possible and what is achievable when it comes to developing a protocol and managing your paper on a particular project. It's important to remember, as Andrew mentioned at the outset, that adjudication is 6 months away. So now is the time to start having those conversations and to start developing and implementing a protocol. It will be a lot easier to do now in the so-called calm before the storm than it will be after you've received your notice of adjudication and need to figure out how to respond. And on that ominous note, we are going to turn it over to our colleagues Brendan and Lena.
Well, thank you, John and Max. And I must be a lawyer because I didn't find that to be an ominous note. I found that to be a positive note. But forgive me, I'm a lawyer, I guess. But I'd like to thank you for sticking with us. Going back to Andrea's original introduction for a moment, if I may, Lena and I will be concluding the program. So thanks very much for joining us and sticking with us for my portion and Lena's. We're going to pick up on the adjudication topic. Which I think John and Max very thoroughly and in a very good way, I think, covered some practical things that you need to think about in terms of getting organized for adjudication. We're going to be talking about some of the legalities of it now. How do you deal with an adjudication award that you don't like? Because inevitably, I think, just as there are with court decisions and arbitrators' decisions, an unhappy party and a happy party, the same will be true for adjudication. So how do you deal with that? Also, how do you deal with adjudication in the context of ongoing arbitrations and litigations, which of course are still going to exist? So how do those two things interplay with each other? So Lena will really be focusing her remarks on those things. I'm going to segue for a moment into the world of alternative finance procurement. I'm going to pretend that I'm an expert in that field. It's not really my area of expertise, but it is something that has now been, I think, as you heard in the very first section of our presentation, been introduced into the Act, and it's been modernized to that extent. So I'm going to focus on how adjudication will work in AFP projects, and then I'm going to tee up the issue that I talked about, what to do if you're unhappy. So if I may start with a shameless plug, actually, on my AFP topic, and it's because I was thinking about the concept of modernization, which I think this was one of the fundamental things that drove it, the new legislation that we're now all dealing with, was the idea that the Act needed to be modernized. One of the areas that people pointed to was that, as in other parts of the world, in Ontario, we had started constructing major infrastructure projects through the use of alternative finance procurement. Put in its simplest terms, the designer, builder, if it's a consortium doing both, or the builder and the designer together, are in effect financing the construction until substantial completion, as opposed to your more traditional model. Very different, and the Construction Lien Act always seemed to rest somewhat uncomfortably on the shoulders of those projects. So that has now been addressed. And the shameless plug is this. If you go to our website, under the Publications tab, there is a paper that my colleague John, who you just heard from, co-authored with Soisic Renel de Saint-Michel, called The Simplified Guide to Modernization of the Lien Act, I think it's excellent in all respects, but particularly in this respect, in getting your mind around how the modernization regime works on AFP projects, it's particularly good. I'm going to keep my remarks on it much briefer than that. I would urge you to go to that full paper to get more detail. And indeed, I'm not going to go into any real detail on these statutory provisions either. This presentation will be available on our website as well. The points I'd like to highlight for you are this, is starting with the bringing of it into the Act, and let's just move on, to the definitions that have been modernized. In the past, as these projects started to come into play in Ontario over the last decade or so prior to this legislation, it was really maybe not a matter of a guessing game, a very educated guessing game, but it wasn't literally known whether or not a project co, for example, who had entered into a project agreement with a government entity as owner, would be considered to be a contract, capital C contract for the purposes of the Act. And indeed, that government entity, would they be the owner, or was it Project Co who would be the owner? Because the Project Co was fulfilling one of the traditional functions of an owner, of course, which is paying for the construction as it happens. So that's now been clarified, and in its simplest terms, the project agreement will be considered to be the contract for the purposes of the Construction Lien Act. The contract downstream between either the design-build entity or the builder who's subcontracted the design will be considered a subcontract. In other words, between the Project Co and Build Co, if you will, is a subcontract for the purposes of the Act. So for those of you who are familiar with all the implications and consequences of that, that's now all baked into the Act. So adjudication is going to be included, just as prompt payment is, as Andrea and Heather went through with you. And as they highlighted in their presentation, there are important exceptions. Just as with prompt payment, there are important exceptions with the way adjudication is going to work on these types of projects. So the main ones are on the slide, but of course they're that certain fundamental concepts on these types of projects are not going to be capable of adjudication. In other words, you're not going to be able to ask an adjudicator to determine whether that contract between Project Co and owner is substantially complete. You're not going to be able to ask an adjudicator to determine whether or not the subcontract, I guess, between the design-build entity and Project Co has been substantially performed. Those are exempt. Similarly, the concept of milestone payments, which is really fundamental to AFP projects and how payments work on them, is also going to be exempt in the sense that you're not going to be able to ask the adjudicator to determine if a milestone has been achieved. So some pretty important exemptions to be aware of. The last bullet, just quickly, is any prescribed matters, means the regulations. That's where, if there's anything else that's going to be exempt, that's where you'll find it. At present, and I stand to be corrected, of course, I don't think there's anything else that's presently a prescribed matter that's excluded from adjudication, but that's definitely something to keep an eye on, because as this thing unfolds and starts working, if they want to exempt anything else, that's where it's going to be found. Another big difference, and this is very interesting. Normally, if I can use that expression, once we get adjudication on a regular construction project, you're not going to be able to nominate your adjudicator in the construction contract. That happens later, as John and Max explained. In AFP projects, very different. There's a very well-developed system of using independent certifiers on these projects, and I think for that reason, they're treated a little bit differently. In terms of how an adjudicator gets nominated. As you can see from the slide, not only is it possible to have your independent certifier act as your adjudicator, in fact, you shall do that, with an important caveat, which I'll get to in a second, but it in effect means that at the point in time where the project agreement is entered and an independent certifier is named, that person, in effect, is also going to be named as an adjudicator. So fundamental difference if you're dealing with projects in this AFP world between the so-called normal situations. So the caveat, though, as I mentioned, is this, is that they have to be registered with the nominating authority. Time is passing quickly, isn't it? It's only 6 months away. Again, this is all subject to transition provisions. It's going to be for things that are procured or entered into after October 1st, but it's going to be here quickly. So I think what this means, practical takeaway is this, is for people in this world, they're going to be using their independent certifiers as adjudicators, and those independent certifiers are going to have to get themselves nominated if they want to stay in business. That's my reading of this anyways. So let's leave AFP, that specific world, for a moment and go back to more general principles that could apply to any project. And I'm going to just quickly tee this up, and Lena's going to go through it with you in some detail, and that's this. You're unhappy. You don't like the decision. The adjudicator has ordered you to pay an amount, and you think it's outrageous. The contractor wasn't authorized to do this extra. It's too much money. The quantum is wrong. All the usual stuff. What do I do? Or vice versa. You think you've got a great claim, and the adjudicator has said, no way. Not getting paid. Dismissed. Adjudication, to get back to some first principles, at least as we understood how it was operating in the UK, was meant to resolve these things in a quick way, in real time, as the project unfolded, deferring expensive litigation with traditional full processes of evidence to later. So in other words, what it means is, and this is why I think it really is coming in with prompt payment, is that the cash is supposed to flow in real time on the project as it happens, and it's very difficult to stop that from happening. And flip side of that coin is trying to remove disputes as a blocker from projects progressing, in the sense that if you don't like the fact that you're not getting paid, your excuse for not working might be removed if the adjudicator says you're not entitled to the money. So how do you actually challenge these things in real time? It's going to be through judicial review. And indeed, if you want to stop the flow of payment, you would have to, as part of that judicial review, apply for a stay. The lawyers, at least on this webcast, will know that both of those things involve a rather high bar and onerous test. So I think as a practical matter, what this means is the money will flow in real time in the project as these adjudications are decided. Now, Lena will talk about the specifics of how judicial review is going to work.
Thank you, Brendan. So as Brendan said, the Act provides for specific reasons for setting aside an adjudicator's determination. There are 7 specific reasons, and I'm going to go through each of them. So the first one is if the applicant who participated in the adjudication was under a legal incapacity. So an example of that would be if an insolvent company has a trustee appointed, but the trustee did not participate. The second reason is if the contract or subcontract is invalid or ceased to exist, and that's got to be at the time that the adjudication is referred to the adjudicator. And you can see, to a certain extent, if not to a large extent, whether or not the contract or subcontract is invalid or has ceased to exist is going to depend on the terms of that contract. The next reason for setting aside a determination is if that determination was of a matter that may not be the subject of adjudication or a matter entirely unrelated to the subject of adjudication. So as Max and John have talked about, there are specific matters that are supposed to be subject to adjudication, and as Brendan has talked about, there are exemptions to what could be adjudicated in the context of AFP projects. The next reason is if the adjudication was conducted by someone other than an adjudicator. Now, an obvious example of that is if you have an adjudicator who's not actually qualified, as in doesn't hold a certificate of qualification and is not registered with the authorized nominating authority, then it's pretty obvious that person is not supposed to conduct an adjudication. The other example I think that could be caught in this ground is if you appoint Bob to adjudicate and Bob gets someone at his firm to conduct the adjudication, then that determination could be set aside. The next reason for setting aside a determination is if the procedures followed in the adjudication did not accord with the procedures to which the adjudication was subject, and that failure prejudiced the applicant's right to a fair adjudication. So here, it's important to remember that the Act actually allows parties to design their own adjudication procedures so long as those procedures in the contract do not conflict with the procedures in the Act or the regulations. This one raises a lot of questions. So one question that comes to mind is what provisions of the adjudication regime, Part 2.1, are procedures such that you could modify them and set them out in your contract, and what provisions are substantive so that you may not be able to do that. The other question that comes to mind is what exactly is a procedure that conflicts with the Act or with the regulations? What if the Act is, or the regulations, what if they're silent on something and you want to put it in your contract? So an example of that would be, going back to what John and Max talked about, if you want to put, what documents should an adjudicator see? What if you put a limit on the number of documents or on the type of documents that an adjudicator could refer to? Does that mean now you've set out provisions that conflict with what's in the Act or the regulations? Really what this means at this point is that, like I said, there are more questions than answers. And if you're going to be drafting contracts that alters the provisions to the adjudication procedures, or if you're going to be entering into a contract where these procedures are altered, you want to think really carefully because there's a risk that you may not be able to enforce those provisions or that the determination could be set aside on judicial review. The last two reasons for setting aside an adjudicator's determination goes to the conduct of the adjudication, which is reasonable apprehension of bias, and if the determination was made as a result of fraud. So just very quickly, going back to what Brendan said, you can see that the intention of adjudication is to get cash flowing quickly because, and this is one way you can see it, is that the application for judicial review does not stay the adjudicator's determination. So if an adjudicator orders cash to flow, it's supposed to flow within 10 days unless you can convince a judge of the divisional court that it should not. And as we've said, an adjudicator's determination is binding until a determination by a court or an arbitrator. There's nothing in the Act that says when you can commence a proceeding in court or bring an arbitration after the adjudicator's determination. So while the reality may be that parties may wait until the project is near completion to do so, you could, in theory, commence an action the day after you receive an adjudicator's determination because nothing prohibits you from doing so. So what that means is when you get an adjudicator's determination, you really have to choose which route you want to take, whether you want to apply for judicial review, which you must do very quickly, or whether you want to commence an action in court or bring an arbitration, which you can do at any time subject to any limitation deadlines you have. Thanks, Brendan. So this is our last slide, and this is a fundamental change as well. We just wanted to highlight for everybody. And the point of this is that adjudications can extend a party's deadline to preserve a lien. And that's if the subject matter of a lien that is not expired is the subject matter of an adjudication. Then for the purpose of this section, your deadline to lien expires on the later of the date which it would normally expire, and the 45-day period after the adjudicator receives documents. So again, that's a fundamental change, and just note that it's not the determination of the adjudicator that triggers the 45-day period, it's the receipt of documents.
Yeah, and if I might, and as Lena said, this is our last slide, so I promise I'll be very, very brief. The change here to me is fundamental, as Lena said. It would be the equivalent of, the legalization of cannabis under the criminal code. is introducing the concept of extension to the Construction Lien Act or Construction Act or Mechanics Lien Act, I guess, if you're really old school. And what do I mean by that is fundamentally for the longest time, and indeed my entire career and going back decades, the concept of liens expiring on very tight and flexible deadlines has been a reality. So just as, you know, in society, it was always kind of a reality, at least in my mind, that you couldn't just consume marijuana legally, and now you can. I didn't before the podcast, by the way, but you know, you now have this concept that the lien rights can somehow be extended. This is an extremely foreign concept and difficult to get your mind around. So the reason I just wanted to end on this is that I think you have to approach this with extreme caution. I think partially this section is benign. It's benign in this sense in that I think what it means is if you're adjudicating during the life of a project, which is often when these things are going to arise, and your lien rights are still well down the road, this doesn't affect them, right? Because it's the later of. So the fact that you're in an adjudication, it's the later of the expiry of your lien rights under the Act that's still going to apply. Where it's going to get tricky is if you're relying on the receipt by the adjudicator of documents as a means to preserve your lien rights. And the reason I'm a bit troubled by that is it's not quite as clear and discreet as something like publication of a certificate of substantial performance. I think there's bound to be some confusion created by that. As John and Max have gone through in their presentation, there's some flexibility in terms of the potential length of the adjudication itself, and indeed where ultimately these rules are going to land. So it's, you know, a reality, I think, that oftentimes people don't want to spend money and register a lien until they absolutely have to. They're going to want to wait until they get the adjudicator's decision, and the timeline might be extremely tight by that point or indeed elapsed. And I think it's going to be a dangerous game. So there is this concept of extension, but I would approach it with extreme caution. So, and we do have a question that I'm just reading for the first time, so we'll see if I'm able to handle this. Is there an update as to the forming of the ANA? Well, I may defer to some of my more learned colleagues here, but the best information I have is that they're looking for someone to serve that function right now, but it's not in place yet, and I think there's still a lot of work to be done, and I'd be happy to defer to one of my colleagues who may have more to offer on that.
Again, the information is very limited, but the Attorney General's office has gone out for bids from various interested parties who want to set up the ANA and then administer the ANA on behalf of the Attorney General's office. I think that's where it stands, and hopefully the Attorney General's office will make a decision soon as to who the winner will be of that bid process, and so that the ANA can get established, as the ANA is very central to the adjudication process. Andrea, do you want to close us out?
So thank you, everyone, for joining us today. Just wanted to let everyone know that the slides from today, as well as a recording of this webcast, will be posted on our website in the next few weeks. And if anyone has any other questions coming out of this webcast that you haven't had a chance to ask, please send us an email at info@glaholt.com whenever the question comes to you. Thank you.